customary international humanitarian law equally applies, which is based on the HR as well. So why your council is more emphasis on ICCPR's treaty-based provisions to be implemented, rather than the customary international humanitarian law to apply on the situations, keep separate the situations of the armed conflict and the peacetime situations?
Your Excellency, in the present case, since there have been grave violations of the human rights of the 42 detainees which were captured by the Arcanian armed soldiers, hence the international human rights law, that is ICCPR, comes into play, along with several rules of the customary IHL which have been developed over time, which will be dealt by the...
Developed, do you know? Customary IHL rules?
Your Excellency, customary IHL has developed over time on the basis of opinio juris and state practices of the states. It is not a codified law, but...
so it's before the ICCPR came into the existence, is it?
Your Excellency, it has evolved over time.
Yeah, so which come first?
Your Excellency, the ICCPR came first because it has a definite date of...
1977.
Yes, Your Excellency.
66 is ICCPR, 1966.
Yes, Your Excellency.
Yeah, and Geneva started in 1809. Yeah? Oh, go ahead.
The applicable framework, that is the ICCPR, to which Armenia is a state party, multiple violations have arisen, for which Your Excellencies may refer to 1.2.5 on page 16 of the memorandum. Article 7, that is prohibition of torture, is breached through acts of torture such as sleep deprivation and solitary confinement, while Article 9, that is prohibition of arbitrary detention, is violated due to prolonged detention without charge, judicial review, or legal counsel. These acts also violate Article 10, which guarantees humane treatment of detainees, and Article 14, which ensures the right to a fair trial, both clearly denied here. Since Armenia has not derogated from its obligations, and as international human rights law applies even during an armed conflict, these violations remain fully actionable. Lastly...
Counsel, may I ask?
Yes, Your Excellency.
We have been talking about the violations. On record, there is not a single instance evidence that violations have been done. Do we have any evidences?
Your Excellencies...
You are before the ICJ and without any evidence.
Your Excellency, if you would kindly refer to paragraph 4 of the Moot proposition, which, no, paragraph 5, sorry, which clearly lays down that according to the reports by former detainees...
Where are we?
Your Excellency, paragraph 5 of the Moot proposition, first page. Yes, Your Excellency. Yes, Your Excellency. The third line clearly states, according to reports by former detainees and other independent observers, there was sleep deprivation, continuous solitary confinement, and stress positions. This proves to be a conclusive evidence because in such a situation, a report by former detainees can said to be a credible evidence regarding the torture meted out by the Republic of Armenia towards the detainees.
Yeah, I read that. And do you think that is the violation?
Yes, Your Excellency.
How?
Your Excellency, according to United Nations Convention Against Torture, Article 1, it has been clearly laid down that any severe mental or physical harm or agony to a person shall constitute torture. In the present case, sleep deprivation, continuous solitary confinement, and stress position not only constitute a physical harm or agony, but also constitute a mental agony, and hence they shall fall under the ambit of torture. And hence, the Republic of Armenia can said to have committed torture. If Your Excellencies are satisfied, the Council would like to continue. The use of sleep deprivation, prolonged solitary confinement, and stress positions amounts to torture, for which Your Excellencies may refer to 1.2.6 on page 17 of the memorandum. Such techniques, when used in combination, intensify suffering and fall squarely within the definition of torture under international law. The Republic of Armenia has hence, therefore, also violated their obligations against under UNCAT. Respondent state is in clear breach of its international obligations. The jurisprudence of this honorable court has consistently affirmed that while IHL operates as the lex specialis, because it is a special law made for conflict situations, it does not displace or replace IHRL, which is a lex generalis. Rather, the two operate in tandem, as has been also talked about the council previously. Thus, Your Excellencies, the legal position is clear. The situation in Northern Arcania triggers a dual legal regime, ensuring that even in times of conflict, human dignity and fundamental rights remain protected. In light of these submissions, the applicant respectfully submits that the situation in Northern Arcania constitutes an NIAC, and consequently, the actions of the respondent are governed by the concurrent applicability of IHL and IHRL. The council would now like to invite the learned co-counsel to proceed with the following
Before
issue.
that, I had one additional question, which is in furtherance to my earlier questions again, which I did not get a satisfactory answer. So I would like to now ask it very lucidly. Do you think this organization, PFLN, according to you, is a terrorist organization? Or has the tendency of a terrorist organization? Are there actions against the interest of a sovereign state?
Yes, Your Excellency.
So if their actions are against the national security of a sovereign state, the sovereign state has all the power to counter that organization, isn't it?
Yes, Your Excellency. The Republic of Arcania
So
has...
why, as another state, why are you trying to formulate your case in support of a terrorist organization?
Your Excellency, the Republic of...
It seems from your pleadings, it appears that you want PFNL to and destroy the sovereign mechanism of this state. So my question is, your case, your pleading suggests that you are in support of a terrorist organization.
no, Your Excellency. What the applicant, the Republic of Khartoum, is trying to contend that apart from the fact that PLFN is a terrorist organization is not being supported by the applicant at all, because the applicant has...
Their actions are, if you see the Moot propositions, they have also taken actions which are completely contrary to principles, right?
Your Excellency, the need for the interference by the Republic of Khartoum has arisen because of the grave violations of the international law by the Republic of Arcania, mainly the international human rights law. Because in the present case, the case primarily here is regarding the dual protection, regarding the diplomatic protection of the dual nationals. And since the dual nationals are nationals of the Republic of Khartoum, hence they've come before this court to seek protection for their nationals and not to seek protection for the actions committed by the PLFN. If your lordships are satisfied, the council would like to invite the learned co-counsel to proceed further with the submissions.
What exactly the disadvantage to the state if it has been counted a peacetime situation or internal disturbance situation rather than the NIAC? Why you are so much insisted to consider the situation as NIAC?
Your Excellency, it is imperative to hold the situation as an NIAC so that this honorable court takes diligence of this, takes this situation into consideration and holds that the influx of refugees that has been happening into the Republic of Khartoum.
Internationally, the advantage that the state should have if it has been counted this situation is non-international armed conflict rather than the internal disturbance.
Your Excellency, I would seek a 30-second extension. Your Excellency, if in the present case, if the situation is determined as a non-international armed conflict, it can be dealt better by the International Court of Justice, provided the threshold of intensity has been reached, as was submitted by the Council in previous submissions, that the situation, the intensity at which the violence or the conflicts have reached, it has reached beyond the domestic laws. It has been affecting another state, and hence it becomes imperative for the state to seek a remedy before this honorable court.
only one last point. If the you cited the ICTY's case, is it a persuasive value or it is binding to an ICJ at this stage?
Your Excellency, since the case is the case of ICTY, it does not hold a binding value upon the Honorable Court of International Justice. But it does hold an important value in this present case, because the prosecutor versus discotheque case plays a very important role in determining whether a situation amounts to a non-international armed conflict or not, because it establishes the two main criteria to determine an NIAC. If your lordships are satisfied, the council would like to invite the learned co-counsel to proceed further with the issues.
The whole scenario looks like a proxy war. And you want the ICJ to be part of a proxy war effort to create disturbance in your enemy territory. A quick one.
No, Your Excellency, the present case is not a proxy war, because it is a clear case of armed violence raised by an internal group of a particular country against their own country, but against the government of their own country. But since the intensity of that armed group, the violence or the actions committed by that armed group has reached a stature that it has been affecting the neighboring states, and also, as the council has previously stated, there also exists an erga omnes obligation, and hence the council humbly pleads that this situation cannot be considered a proxy war.
You can advise your client to have more missiles. In the present day context, they fight wars with missiles, not proxy wars. That's fine.
The council would now like to invite the learned co-counsel to proceed with the following two issues.
Greetings of the day to the bench. May it please the Honorable Court, the council appears on the behalf of the appellant and will be dealing with issue number 2 and 3. If your excellencies are satisfied, the council would like to begin with the arguments. Much obliged. At the outset, the issue strikes at the very foundation of the humanitarian protection in situations of an armed conflict. It raises a simple yet deeply significant question, that is, whether a state can place individuals outside the protection of international law merely by assigning them a label that is not recognized by the law itself. It is very respectfully submitted that such an approach is impermissible. The council humbly submits that at the heart of the issue, the heart of the case lies not just a question of law, but a question of human dignity, accountability, and the very limits of a state power. The council respectfully submitted that persons captured during the conflicts must be treated as persons deprived of their liberty rather than classifying them as illegal combatants. It is humbly submitted that the persons captured in the international armed conflict cannot be classified as unlawful or illegal combatants. According to the international law, there exist only two categories in which the persons can be classified in a conflict, that is whether either a combatant or a civilian. There exists no third category or intermediate classification, and there is certainly no recognized legal status of so-called unlawful or illegal combatants. In the present case, 42 individuals were apprehended during counter-insurgency operations and subsequently detained at Camp Ironclad, a high-security military prison operated by the Armenian Armed Forces. These individuals were held under conditions of sleep deprivation, and they were persons who were deprived of their liberty. Such treatment directly violates Common Article 3 of the Geneva Convention, which mandates that all persons taking no active part in hostilities must be treated humanly, in all circumstances and without distinction. This obligation is further reinforced by the Additional Protocol 2, which applies specifically to non-international armed conflict and requires humane treatment and fundamental judicial guarantees.
Main distinction between Common Article 3 of GCs and AP2, when AP2 would apply with the Common Article 3?
Your Excellencies, Additional Protocol 2 applies in the condition of a non-international armed conflict.
Understand. So, Additional Protocol 2 is an extension of the Common Article 3. But when only the Common Article 3 would apply and would be hesitate to apply the Additional Protocol 2?
A moment. Rights were systematically violated. The detainees were not informed of the reasons of their detention. They were denied access to the legal counsel. They were not produced before any judicial authority, and they were subjected to enhanced interrogation methods, which are torturous in nature. In light of such grave violations, the applicant state has invoked diplomatic protection on behalf of its dual nationals among the detainees due to absence of any effective remedy. The respondents attempt to create such a third category. The
Because
category.
two terms you used simultaneously. One is unlawful combatant and other is illegal combatant.
The classification that the Republic of Armenia has done as unlawful combatants, which is not permissible, as such a category does not exist under the international law.
But protection can be given to them under the humanitarian law.
Your Excellencies, this is what the Council is pleading. The Council pleads that creating a third category would create a vacuum and not placing them under the protection of any international law
So
will deprive
they
them.
protected? They won't be protected?
No, Your Excellencies.
Then what's the value of customary international law?
Your Excellency, the Council pleads that under the international law, again, two categories are the ones that are recognized. Thus, classifying them as unlawful combatants will deprive them of their basic human rights under the international law. And therefore, the Council pleads that classifying them as unlawful combatants is not permissible.
Who are these 42 people? From where were they arrested?
Can you please repeat?
In the proposition, it's written, in the process, 42 people were caught at the military checkpoints. night raids, and active hostilities.
Yes, Your Excellency.
And what kind of people are arrested at these points? Are they humans? I mean, I'm not saying that they are not humans. I mean, do they really claim to have human rights when they are waging a war against their own state?
Yes, Your Excellency. The Council humbly submits that even though the persons that are detained maybe amidst proxy war against their own state, but even after all this, they are still human beings who are subject to some basic human rights that are bestowed upon to them by the international law, some basic fundamental human rights, and the Republic of Armenia cannot violate those on the grounds of protecting the sovereignty of the state.
So to what extent a state can go to protect its sovereignty?
Your Excellency, the Council pleads that merely detaining the soldiers would have resolved the issue to a huge extent, but depriving them of sleep, enhanced interrogation techniques, and solitary confinement leads to the violation. If the main issue before the Republic of Armenia was just to protect the sovereignty of the state, merely detaining them under by lawful means and by lawful grounds would have resolved the problem.
Now, this is a clear case of interference in the domestic affairs of a neighboring country.
Yes, Your
You don't
Excellency.
decide how I'm going to treat the traitors or the wages of war against my sovereignty. And when the war happens, there are rules. Now, do you think that these people would have been kind to my armed forces? I mean, so not mine, but the armed forces of Armenia? If they had the opportunity of killing them? They
Certainly.
were not fighting under the color of any flag, any country. Legal status they have. And I don't understand how come Khartoum is so much concerned about such illegal outlaws in a neighboring country.
Much obliged, Your Excellency. I would like to answer that Republic of Khartoum, under the obligation of erga omnes, is taking this case to the International Court of Justice because the international rights of the detainees are getting violated, who are the dual nationals of the Republic of Khartoum as well. So, as it is a responsibility of the state to protect the civilians, the Republic of Khartoum is before this honorable court for the protection of the civilians. The council? Yes, Your Excellency. No. The council would like to plead that no status determination process was carried out to classify the detainees as unlawful combatants, and therefore we plead that the classification of them as unlawful combatant is impermissible. If Your Excellencies are satisfied, the council would like to proceed with the third issue. Much obliged. The council, the council would now like to proceed with the next issue, that is issue number 3 concerns whether the Republic of Armenia bears international responsibility for the violations of international humanitarian law and international human rights law committed by the armed forces and non-state militias operating with its support or under its control. The Council humbly submits that the Republic of Armenia bears the international responsibility for the violations committed by the armed forces and by its affiliated militias. Under Article 2 of the International Law Commission, Articles on the Responsibility of State for Internationally Wrongful Act establishes two conditions for internationally wrongful acts by the state. These are, first, the act should be attributable to the state, and secondly, there should be a breach of the international obligations. The Council humbly submits that the Armenian armed forces are directly attributable to the state, as according to Article 4. Article 4. Yes, Your Excellency. Your Excellencies may please refer to page number 28.3.1.3, wherein the Article 4 of ILC is stated, the conduct of any state organ shall be considered an act of the state under international law, whether the organ exercises legislative, executive, judiciary, or any other functions, whatever position it holds in the organization, and whatever character as an organ of the central government or the territorial unit of the state. Further, Article 7 clearly states that the conduct of the state or a person or entity shall be considered the act of the state even if it exceeds its authority or contravenes instructions. In the present case, it is clearly mentioned that there has been breach of the international obligations by the Arcanian armed forces, and therefore the two essentials under Article 2 are fulfilled, and therefore acts of the Arcanian armed forces are attributable to that of the state of Republic of Arcania. Now moving further to the acts of the non-militias, Article 8 of the Article 8 of the ILC, which is mentioned on page number 31 of the memorandum, states that the conduct of a person or a group of persons shall be considered an act of state under international law if the person or group of persons, in fact, acting on the instructions of or under the direction or control of the state is carrying on the conduct. So here we can, in the present case, it is held that the non-affiliated state armed forces, they acted on the instructions of the Republic of Arcania, and therefore their conduct is attributable to that of the Republic of Arcania, and there has been again a breach of international obligations. And therefore the much obliged, Your Excellency, the Council. Your Excellency, the Council would request this Honorable International Court of Justice to hold that the Republic of Arcania, in this present case, is responsible for the violations of international obligations, and also of the non-state militias, and their contention of holding them and classifying them as unlawful combatants is illegal. And this being an international matter, the Republic of Khartoum requests this International Court of Justice to kindly consider this particular case and prevent the international violations that has been taking place against the detainees of the Republic of Khartoum. Yes, Your Excellency. In the present case, it was mentioned that the international... Yes, Committee on the Red Cross weren't allowed to take reports, and therefore the Council here...
Customary rules which ICS is allowed to visit.
A moment, Your Excellency. For this, Your Excellencies may kindly do page number 27 of the memorandum, 2.3.4, which mentions Rule 124 subclause B of the customary IHL, which specifies that in an international non-international armed conflict, the ICRC may offer its services to the parties.
ICRC is an NGO on which international community rely, or it's intergovernmental organization, or can say that it's an independent body to see the situations where it is written. Mandate receives ICRC to visit the field at the time of armed conflict. Emerged from where? Which is the source? Is there any role of the General Assembly?
For this, Your Excellence may please refer to page number 27, 2.3.4. The last 4 lines clearly mention that the 25th International Conference on the Red Cross appealed to the party involved in armed conflict to grant regular access to ICRC to all prisoners in armed conflict covered by international humanitarian law. It can therefore be conducted.
Where is the footnote? Where is the footnote? Who gives mandate to an ICRC? That's what my question is. Who is giving mandate to an ICRC to visit field of conflict? Is there any role of the General Assembly there?
Apologies, Your Excellency.
Resolutions?
The Council is not presently aware of.
Please.
One additional question I had. You have referred in your pleadings to these 2 judgments of Tadich case and Nicholas, United States of America.
Yes, Your Excellency.
And you have sought reliefs on the basis of these judgments. So, are you aware of the facts of these 2 judgments?
Yes, Your Excellencies. Firstly, in the case of the Nicaragua versus United States, the United States, in the government of in the Nicaragua wasn't supported by the United States of America, and therefore they established a group which was known as the Contras and funded them, trained them, and also supplied them and to go against the government of Nicaragua, and therefore the government appealed before the International Court of Justice as they appealed.
The other case?
Tadic versus in the case of prosecutor versus Tadic, the Tadic was a Bosnian Serb and he was accused of torture, cruel treatment and inhuman acts, and there were crimes committed in detention camps, and the victims...
It's okay. I just wanted to see if you knew the facts on it.
The council would like to state the prayer. The council seeks an extension of a minute for stating the prayer. So the council may plead the prayer or... Okay. Much obliged.
The council seeks permission to address the bench collectively as Your Excellencies. Much obliged. With due permission of Your Excellencies, the council would like to submit compendium for the side of respondent. Much obliged, Your Excellencies. Would Your Excellencies require the council to recite the facts of the case very briefly? Certainly. Sir, much obliged, Your Excellencies. Indeed, Your Excellencies. Briefly stating the issue allocation between the speaker 1, that is I, and my co-counsel, I will be dealing with issue 1 and issue 2 respectively, and my co-counsel will be dealing with issue number 3. If Your Excellencies are satisfied with the issue allocation, the council will now begin with the arguments. Much obliged, Your Excellency. The council will be now dealing with this issue number 1, in twofold manner. First, establishing that the situation in Armenia does not constitute to be an NISE, and secondly, establishing that what are the legal framework then applicable in our country, that are our own domestic laws, Your Excellencies. Your Excellency, the council kindly requests you to please refer page 1 of argument advanced, paragraph 3. Sir, Your Excellency, not the Roman number, page 3 of argument advanced. Yes. Page, yes, page 3, paragraph, page 1, paragraph 3. Is Your Excellency with the council? Indeed. Yes, yes. Your Excellency, for any situation to classify as an NISC, it must be established that there exists an armed conflict. Now, with regard to the compendium provided, Your Excellency, the Council requests you to kindly refer page 5 of the compendium, paragraph 70. Which defines what is an armed conflict, which was defined in the landmark judgment of Tadic. Your Excellency, the situation which exists in Arcania is certainly not of an armed conflict. Rather, it is an internal disturbance. The Council, for the sake of clarification, draw a distinction now between what is an armed conflict and what is an internal disturbance, Your Excellencies. Armed conflict entails prolonged, organized armed violence between state and non-state groups, which triggers the legal framework of IHL application. However, in the present case, PLFN have been engaged in sporadic acts of violence. It includes isolated, occasional, with a lack of continuous and organized nature of violence, Your Excellencies, all of which falls under the ambit of internal disturbance. Backing it up with the facts, Your Excellencies.
The clarification to a bench is, how do you recognize that the members are a non-state actors?
Your Excellency, the Moot proposition.
Now, what are the conditions to be fulfilled to recognize that group as a non-state actors?
The Council requires a moment to answer to Your Excellency.
Yes.
Your Excellency, for a condition to be a non-state actor, pertaining to this particular situation is that they do not they are not a state, for one thing, and second, they do not follow any public function. Adding on to that point, when we say that they are non-state actors, we are not just stopping to that level, Your Excellency. We are saying that they are
Under the IHL, the threshold is required to decide which are the threshold limit to consider any group as a non-state actors. There must be a law, there must be rules, there must be explanation by an international reports. So my question is, first you justify that this group, because your argument is they are terrorist group, how terrorist members groups distinct than the non-state actors under the IHL?
indeed, Your Excellency. So, drawing upon the landmark judgment of Tariq itself, which establishes.
Tadic case is okay.
Okay.
Tadic case is justified they are non-state actors, but there must be a conditions to be fulfilled by those members considered they are non-state actors and they are not a terrorist or vice versa.
All right. Indeed, Your Excellency. Here the Council would like to cite the UNSC resolution 1566, which was in the year 2004, which defines what is a terrorist organization. A terrorist organization is the one which commits criminal acts against.
Not what considers its terrorist organization. My question is, to whom you consider they are non-state actors?
How as non-state actors.
Non-state actors and not terrorist members. Group of members.
Your Excellency, we are considering them as a terrorist organization.
Why?
And in order to
Why
answer.
they are not non-state actors?
Indeed, Your Excellency. We are not saying that they are not non-state actors. However, adding on to the point that they are just not merely a non-state actor, they are a terrorist organization. Non-state.
Not been given.
All right.
Terrorist members and the non-state actors in IHL. If they are terrorists, obviously the IHL would not be applicable to those groups. Members.
Your Excellency, there lies a simple distinction between de facto and de jure. The PLFN, they consider themselves to be de facto having military and political jurisdiction over the Norland region. However, they do not have the de jure power per se. It is the state of Arcania which have the de jure power. They are the government which has been there in place. And in furtherance to the Moot proposition itself, it mentions it to be, PLFN has been stated to be non-state actor. However, also in the Moot proposition, the Arcania have
I think, see what my very basic point is, if any terrorist being arrested,
Sorry?
any terrorist being arrested, then
Right.
obviously the domestic law of the state it's going to prosecute.
Yes.
But under actually non-state actors
Yes.
are being arrested, detained, then Geneva Convention is going to apply, right?
Uh,
It means that there must be a distinction between a member of a non-state actor and a terrorist.
you're
Right? So my question is, how do you identify that this group, members who are from the liberation movement, they are non-state actors?
Your Excellency, I would like to answer your question in twofold manner, with your permission. In the initial part of your question, you mentioned that IHL is being applied. The council here would like to clarify that IHL is not being applied in this case very briefly, because this is not a situation of NISC. Only and only when. Could I just conclude it very briefly? If it's not an NISC, the threshold is not being met. And if the threshold is not being met in this particular case, which the council backs by the facts, they mentions, the learned counsel from the applicant mentioned that there was a command structure. Who is at the hierarchy, your Excellency? Is there any responsible head? Is there any figure that we can pinpoint? We can have responsibility. We can hold them accountable for their function. No, not at all, Your Excellency. They do not have any responsible command per se. And which is why we are here stating that it is not at all a situation of intensity of violence, not even the situation of organized armed group as they claim to be, and which is why it does not incur the status of NISC. Now, with pertaining to the legal framework, Your Excellency, it follows very naturally that since it is not an NISC, the legal framework of IHL would certainly not be applicable in this case. What will then be applicable? It is the domestic laws of our country. Now, the important question,